Trust in Medicaid, a match made in heaven. Like I typically do as I start these events, is I always want to start out with a foundation for those that are new. And elder care and who we are as Tully Law Group and how we do our work has a lot to do with helping new families that are going through these things for the first times. So we'll start in the beginning just for a couple minutes of a foundation. And quite often it's important to understand and to differentiate what is the difference between long-term care and medical care. So that's what we're going to do first. Medical care, well, I'll put it this way, as we get older, right? And there's different things that can happen to us. I mean, here I am in my early 50s, and I dealt with both medical issues and long-term care issues for several months. But as we get older, we deal with either medical issues or long-term care issues. The medical issues are going to be those that are medical in nature. Those are the ones where you're seeing your doctor, you're seeing your nurse, you're seeing going to a rehabilitation center. Medical care is covered by your medical insurance. All right, so we're not here talking about medical issues and surgeries and rehabilitation centers. No, but rather we're talking about long-term care. Long-term care is going to be that longer chronic custodial concern, one that is not medical in nature. And generally, as we age, and quite frankly, over 70% of us, once we hit 65, will have some type of long-term care issue. And here at Tully Law, we have been helping families since 1998 deal with this. So it's been 24 years that I've been helping families both with the planning and the protection, and then of course with the care issues as well. So long-term care is going to be everything that's not medical in nature. Long-term care is going to be what we call the activities of daily living. Long-term care is our functional abilities, not the medical, but it's our functional abilities. What can we do and what can't we do? And that, as I just shared, is best described by the activities of daily living, the ADLs, all right? So again, if we need a doctor, that's medical. Our Medicare, our health insurance, our secondary coverage, our supplemental coverage is covering all of that, okay? I just want to make here, okay, good. All right, good. I just have more people commenting, so I just want to make sure we're good. So the activities of daily living, what we're looking at there those are the functional abilities, and the best way to do it is just give you a list. What are the ADLs? Well, it's going to be literally everything we do in the morning, okay? We get up and out of bed. That's called transferring. We walk to the bathroom. We bathe. We toilet. We dress. We eat. We groom. And there's your transferring, okay? So the activities of daily living really comprise long-term care in New York State right now. But this is all functional. And for many, many people out there, you're dealing with concerns that are not only functional in nature, but also have to do more with the cognitive decline. And that's where the IADLs come in. IADL stands for instrumental activities of daily living, as opposed to the physical activities of daily living. So the instrumental ADLs are, again, more cognitive. It's going to be cooking, cleaning, transportation, being able to drive, take a bus, handling your laundry, paying your bills, as well as shopping, okay? So the reality is long-term care is comprised of the physical, which is going to be your ADLs, as well as the cognitive, which is going to be the IADLs, all right? In New York, for the purposes of getting long-term care paid for, which I'll talk about in a little bit, it's really about the functional. It's still just about the functional ADLs, okay? Now, here at Tully Law Group, we focus on and help families understand this, usually with what we call the elder care continuum. And that's just a graphic, a visualization of what a person may go through as they are entering the long-term care world. On the left, we have no cognitive or functional decline, then represented with a cane, a little bit of limited function, and then a walker, and then a scooter, and then ultimately some more significant limited function, again, either cognitive or physically, and we represent that with the wheelchair there, okay? It helps people to understand that things generally decline as we're dealing with these concerns we always do all we can to keep our families as much to the left, right? We all want to do that for our loved ones as well. All right, so as we start to age and deal with these long-term care issues, though, what are the concerns that we see? A lot. And we don't have all afternoon, so I've summarized it down to how do we protect our house? So as dad is aging and dad needs long-term care, how do we protect our home? How do we protect our financial accounts? How do we pay for the care that we're going to need eventually? And ultimately, how do we help dad? How do we help my wife? How do we help our loved ones get the best care possible? Those are really the tenets of concerns that people come to us with. And the reason those are concerns, it's valid. There's legitimate concerns because if they're not addressed, if protecting the home, protecting the financial accounts, paying for the care, and getting the best care are not addressed, then there are going to be consequences. For example, if the home is not protected and there is a need for long-term care down the road, the family is risking a lien placed on the property by the state. They are risking what's called estate recovery, where the New York Medicaid program, New York State, can actually take money from the estate to pay themselves back. And finally, if they didn't protect the home, they may be forced into a fire sale where they got to sell that home super fast just to protect what they can. All right, so protecting the home in advance, and that's the key, and it always will be the key, protecting your assets in advance will avoid those consequences. Now, protecting the financial accounts, yes, you don't want to waste the financial accounts. You don't want to spend it all on the care either. There is something very valid about, hey, that's mom's money. If mom needs it, we're going to spend it on her. I get that, and I'm all for that. However, if there's a spouse, if there's a child with financial needs or physical disabilities, mental disabilities, we cannot, and it's not prudent to spend every penny of mom's money because she might need more down the road. She might need something else down the road. And if you spent it all now, how are you paying for that later? Or if there are needs of a spouse or a child, okay? Spending it all on the care is not the prudent way to go. It's always a balancing act, all right? If we do use the money to pay for the care, be prepared because home care today, post-COVID, is more expensive than it was pre-COVID. What we're dealing with right now on the home care front is about $150 to $180 a day to start, and it can go up to $300 to $400 a day. Home care can hit an $11,000 number if you're paying for that privately. Nursing homes can be anywhere from $500 a day to about $700 a day for that skilled nursing facility. That's that SNF that I have there. All right, so nursing homes are almost double what it costs for home care. So paying for it privately, most families will do that in the beginning because they have to, because they didn't plan and protect in advance. But the reality is that if you keep paying for it, that's the burn rate right there. All right, getting the best care. I can say this is why we primarily do what we do. Yes, we can protect the assets. Yes, we can get the care paid for. But we want to make sure that your loved one, that you get the best care down the road. It's why we do what we do. All right. You have an aging parent, you have a frail spouse. You want to make sure that they are not accelerating their condition prematurely. You want to make sure that there's oversight. You want to make sure that there's advocacy. You want to make sure that there is a coordination of parties, of providers, of payors, and through care coordination and through advocacy and crisis intervention, we can avoid the consequences of frailty and decline and ultimately avoid a crisis. That's what this is about, all right? That's what makes Tully Law Group stand apart from all of the other elder law attorneys out there, okay? We focus tremendously on those care issues, okay? Now, from here, the way Tully Law Group does this is we focus on 3 domains, all right? And nobody can argue with this. This is the reality of aging. There are 3 domains, 3 areas of aging. The first is the legal, The second is going to be, well, actually, first we'll go to what legal is. The legal domain is going to be, how do we protect the home? How do we protect those accounts? How do we protect the income if possible? All right. Then we have the financial domain, and that is, how do we pay for the care? And finally, we have the care domain, as I was just saying, that is making sure that your loved one gets the best care possible, that there's help navigating the long-term care system, that there is an advocate as your loved one goes through the long-term care system, helping the caregiver, make sure there's support. A lot of families come in here and say, Dad needs care. Okay, but how's mom doing also? All right. Yes, we got to focus on dad. That's where the fire is, but mom might be where the smoke is. All right. So we need to make sure that mom is not doing too much and digging herself a hole in the ground right there. So taking care of the caregiver, and that can be a child as well. It's not always a spouse. It could all be sitting on one child's shoulders as mom goes through all this. All right. Helping the family, supporting them, navigating and allaying and really addressing fears and concerns as they arise. Those are real. What's tomorrow going to hold? Who's going to care for me? Am I going to make it through this? Those issues need to be addressed, and we do that as we help families. Okay. So again, legal, financial, and care domains. That's how we do what we do. All right. So each of those domains has a goal. All right, this is what drives us. So the legal, the financial, and the care. The legal goal, protect the assets. We're going to do all we can to protect the assets and the income as well. Just in every circumstance, we can't protect the income. So we put the goal as protect the assets and the income when we can, depending on the circumstances. On the financial side, the goal for our families in need of care is get Medicaid, and I'll talk about that, to pay for that care. And ultimately, the goal with the care is to make sure your loved one, make sure you are getting the best care possible as you proceed down that elder care continuum, okay? And we are going to be the hands and the support to help you do that. Okay, so we have sometimes a client that comes in and says, why do we have to protect the assets? Why is paying for long-term care an issue? So think about that for just a moment. When we're laying this out for people all the time, the reality is we want to protect assets and we want to get the care paid for. But again, they might be like, why? I know my mom didn't need this, or my dad, we paid for it out of pocket. He didn't have anything left at the end of the day. But why is paying for long-term care an issue? Why is protecting your assets an issue? One thing, it's about the money. Okay. Now, long-term care, as I shared a little bit on a prior slide, is very, very expensive. All right. So how do we pay for long-term care? There's three ways. We could use cash, our savings, our private money, savings account, retirement accounts, annuities, etc. Absolutely. It's your money. If you want to spend on it on the care, go right ahead. In fact, there's a number of families that we work with where that is the option. We do a significant amount of estate planning work for folks with greater assets, all right, than most of us. And in those scenarios, they're not taking advantage of the community Medicaid or the chronic care Medicaid program. They are paying for the care themselves. So for them, it's a reality, and that's fine. They have the ability to do that. But when you're looking at a middle-class family with a house and maybe a couple $100,000 saved, you can't go around spending $100,000 a year on home care. You can't spend $250,000 on nursing home care. That will decimate any savings for future needs. That'll decimate any savings for a spouse that has expenses down the road, and it'll destroy any type of inheritance that the parents worked 40, 50, 60 years for. Okay, so paying privately, yes. Using your cash, yes, it happens in the beginning, but it's not something that the typical family can do in the long term. Then we have what's called long-term care insurance. Most people do not have long-term care insurance. It is a separate health insurance policy that you would have to have purchased. You do have to qualify for it like life insurance. You have to be able to afford it, and you have to qualify medically for it. Okay. The people that we do see with long-term care insurance, most of them do not have a robust enough group of benefits. All right. So we usually end up relying on Medicaid at the end of the day anyway. But long-term care insurance can pay for home care, can pay for assisted living care, can pay for nursing home care, as long as all of it is covered by the policy. That's one part, one variable. Another variable is making sure that you've got enough what's called daily benefit to pay. If you have a $50 daily benefit for home care, it's not going to cover much. If you have a $200 daily benefit for nursing home care, it's going to cover about a third. You're still going to need alternative means. You're still going to need Medicaid to pay for that care. Okay. Now, third and final, I left the word community in there, sorry, but Medicaid itself. Medicaid is a government program. It is a means tested program, meaning they look at your assets and look at your income before they approve, but they have a community program and they have a nursing home program. And that's what we're going to start talking about a little bit. Medicaid is a godsend for many, many families. All right. It's able to actually pay for the care that's needed. And by the way, as I'm going through this, folks, if you have a question, obviously I'm not addressing them now. Stick it in the chat, stick it in the Q&A, and I'll get to it at the end. All right. I promise we'll have a couple minutes at the end to review any questions that you have. All right. If that question, if you don't get your question answered there, then you can, the last slide will have our phone number, 631-424-2800, 424-2800, as well as my email. And you could always just email me directly. I think any clients that we've had, if they're on here, they could certainly attest. Much to my wife's chagrin, I'll be answering emails sometimes on the weekends. But anyway, how do we pay for long-term care? Cash, insurance, if we have it and it's sufficient, and ultimately through Medicaid. So as I was sharing, there are two types of community Medicaid. The first one is what's called nursing home or chronic care, and that covers the nursing home. Nursing home Medicaid has that 5-year look back. Everybody hears about the 5 years. Everybody hears that phrase look back period. That's where you're going to run into issues, because if there's been any gifting or asset protection done within that 5-year look back, that's when we've got problems. All right. All in all, protect your assets, set up your elder care protection plan when you are younger and healthier. All right. We start talking to families about that work at 65 years of age. Okay. Now, because of the look back, we also have those transfer penalties. So we have to be wary of that. Now, community Medicaid, that's been the talk of the town for the last couple of years. Hands down, people want to stay home. Hands down, people wish to be with their family, in their community, in their bed, in their kitchen. And that's how we do it, through the community Medicaid program. So they will, home health care, they'll be able to send an aide in to help with those activities of daily living with some supervision needs. Community Medicaid is also the ALP program, which is the second line there, stands for Assisted Living Program. Community Medicaid also covers adult daycare. So that would be your local senior centers typically, okay? And of course they have them, different rehab centers have daycare programs too. Now, community Medicaid as of today, and this has been the hot topic for the last 2 years, no look back period, no penalties, but we are expecting changes with the look back period, and we are expecting changes with the penalties, okay? Community Medicaid at the bottom there always has care assessments, and quite honestly, that's again where we shine because of the advocacy and the professionals that we have on staff. Okay, next slide. So Medicaid itself, all right? Now, remember, a match made in heaven, trusts in Medicaid. So we're going with Medicaid first. Medicaid is about 3 things. In order to be eligible for Medicaid, you have to be eligible asset-wise, income-wise, and your health, all right? What they're going to do is make sure that your assets are below a certain level on the asset side. And I get into this more, and by the way, just a little commercial here. We have a lot of our webinars over the last 2 years on our website, and we've uploaded them to our YouTube channel, all right? Tully Law Group PC, website, tullyelderlaw.com, where you can check under videos and webinars. We'll have more details about asset eligibility, income eligibility, and health. Just to give you the 2022 numbers, when we're talking about assets for Medicaid, the person, the applicant, your loved one has to be below $16,800 plus retirement accounts. On the income side, $954. That is the monthly income allowed on the home care side. Nursing home is still sitting at $50. And then on the healthcare side, we're still looking at two different types of assessments, where my advocates will be there sitting next to your loved one advocating with the nurse from New York State. Okay. But that is the Medicaid process, dealing with asset eligibility, income eligibility, and all the care advocacy. Okay, so back in April of 20, just as the pandemic unfortunately was getting started, the governor at that time signed into law changes to community Medicaid eligibility. The primary changes were the creation of a 30-month look-back period. Okay, that means, remember, nursing home has that 5 years. That means community Medicaid applications, which never had a look-back period, would have a new 2.5-year look-back. So 30 months versus the 60 months, 2.5 years versus the 5 years. Now, the way that this was set up is any transfers after October 1st of 2020. Okay, so you got to go back to October of 2020. Once this look back starts, any transfers going back 30 months or to October of 2020, whichever is shorter, those will be subject to the penalties, just like nursing home Medicaid. Okay, so if you give money away or protect money in a trust, what you're looking at are penalties, again, once this new law starts, and I'll keep talking about that to make it clearer. The new law also, okay, there we go, have our penalties for that, just like the nursing home. So right now we're looking on Long Island at about a $14,000 number. What that means is, and that's the regional rate for care here on Long Island, is you have a $14,000 divisor, $14,012. So for every 14 grand that is gifted or protected during a look back period, Medicaid will not pay currently for the nursing home. But when this new law starts, then Medicaid will not pay for the home care either for 1 month. All right. This is real, and I believe it's going to be happening. In addition, the third change with this new law is that there will be a higher care need threshold. All right. We've seen this coming. Medicaid, community Medicaid especially, has been harder and harder for the last 8-9 years on the home care front, which is why we have our advocates on staff to hold your hand through that process, to coordinate the benefits, to advocate at these assessments. Currently, when we're dealing with care eligibility in the community setting, we have to show a need with 2 of those activities of daily living. Again, it's more physical, less cognitive at this point. In the future, however, when this new law does eventually roll out, they'll be jumping up that 2 ADL requirement to 3 ADLs, and they're adding a component of physical maneuvering, meaning that the aide, the person assisting, literally has to assist with the physical maneuvering. Okay, that is a much higher standard than what we have now, versus demonstrating a need for 2 ADLs. Okay, all the more reason to get the guidance, to get the support as you jump into this system. Okay, now the good news is that the implementation of this law has once again been postponed. Okay, it's all about the implementation. In the big picture, Governor Cuomo signed this into law in 2020, but due to the PHE, what's called the public health emergency, the federal government prevents any changes, in summary, prevents any changes to Medicaid eligibility. Okay, let's just leave it at that. And what that means is that as long as we are under a public health emergency due to the pandemic, this home care, community Medicaid look back and increased care needs cannot occur. All right. And the little detail there is the changes can't happen during the same calendar quarter that the PHE exists. And the current White House just extended the PHE until April 14th. That means January, February, March, April, May, June. Those are the first 2 quarters. Second quarter is April, May, June. During the second quarter, when this postponement due to the public health emergency ends, these changes can't occur during that second quarter. They have to begin the first day of the third quarter, which is going to be July 1st of 22. Now I have that asterisk there because might it be postponed again? Yes. But to be honest with you, it can happen. It can happen. All right. We've been dealing with this back and forth and postponement. Is it happening? Is it not happening? For over a year at this point, a year and a half. But that's the date we're working on. Now, to throw a little wrinkle out there, the Governor Hochul, has announced in her budget, it's not law, and I don't think it's going to apply with what we're talking about here, but she has proposed that the asset limits, the 16,000, for example, the 16.8, that's removed altogether. I don't see that happening with long-term care. I think it's going to be for other types of Medicaid, not the long-term care-based Medicaid. Okay. We'll see how that bears out with the budget discussions up in Albany over the next several months. Okay. But the reality is that we are looking at a constriction of Medicaid by them making the eligibility harder and harder. So we're here to share with you again that you want to get your planning done. You want to get your protection done as soon as possible. Okay. Because it could happen July 1st, may not, but it could. And if you need to get things done, you just get it done. All right. So, and I talked about the October 1 date earlier. That's where the look back will go back to. So with this being said, folks, we are sitting right now, really, there's an opportunity out here. Okay. What we're looking at from today until June 30th, that is the time frame to, number one, get your planning and protection done. And number two, if you have care needs, that's when you need to file the community-based Medicaid application by. If this law comes into being July 1st and you don't file the needed community Medicaid application until July 2nd, then you've got a look back period, then you've got penalties, then you have a waiting period. So if you're on the fence, if mom has the care needs, now is the time to get your ducks in a row, start the process for planning, protection, and the Medicaid eligibility, okay? The Medicaid application process is not overnight anyway. It's at least 4 to 6 months before it happens, before it's all approved and implemented. So you want to start it sooner rather than later anyway, as long as the needs are there, okay? Now, if the way I look at this is, and a lot of people say, and we have these discussions over here, these Medicaid changes that are coming, it's our position, and then we're right, is they're not just about those that need care. These Medicaid changes also should motivate folks that are healthier and younger, okay? Because if you're sitting here at 65, 67, 68 years of age and don't have any care needs, don't ignore this, because there will be a look back down the road, okay? That will be there for you. And the sooner you get your elder care protection in place, the sooner you start the look back period for the home care and for the nursing home. All right. So again, if you're on the younger, healthier side, now's the time, get the protection done so that you start the clock, go live your life for your 2.5 years, your 5 years. And then Lord willing, if you ever need the care, your protection plan is already in place and the look back clock has started and run and you're in the clear. Okay. So the way we do it over here at Tully Law Group is we have an elder care protection plan service. We will take care of the estate planning. That's going to be, of course, your wills, very, very comprehensive powers of attorney. You can't skimp on the power of attorney, ladies and gentlemen. That is probably the most important basic document there is. And again, I have prior webinars that talk about that on our website and on our YouTube page. But our elder care protection plans will cover your estate planning. We'll get into place the asset protection with the irrevocable trust that I'll talk about in a moment. And bottom line is we'll help you and the family prepare for care down the road. There are care assessments that we look at annually. There's Medicare guidance that we can give as well. So this is step one. All right. When we're talking with a couple in their 60s, this is step one. Get this done. Now down the road, if we have the care needs, the legal needs, the financial needs, the care needs, what we're talking about is a life care plan. That is the service where it is all hands on deck. The elder law attorney, the Medicaid paralegal, and our elder care coordinator. We will help protect the assets, we'll get the plan in place, and we'll get Medicaid to pay for the bill. All right. All the while making sure your loved one is getting the best care possible. The reason I'm talking about this now in the middle of my presentation is because we have from today until June 30th to get going. All right. And again, they might postpone it again, but don't take that chance. If you've got the care needs, get this ball rolling. All right. Now, Medicaid and trusts, a match made in heaven. That's what we've been talking about. So there's our Medicaid portion. We're going to spend a few minutes talking about trust at this time, and then we'll get into your questions. All right. So it's important to realize that a trust is a very, very important tool for many, many families. All right. If you don't have a trust, you probably should. A trust is nothing more than a written agreement. That's all it is. All right. It's not for the Vanderbilts and the Rockefellers, and for the younger folks, it's not just for the Kardashians. A trust is a tool that every family can use. It is a written agreement. That's all. And it's a written agreement that simply says, okay, trust, this trust is going to manage my property while I'm alive and while I'm healthy. It's also going to manage my property while I'm alive and not healthy. And then ultimately, the trust is going to distribute my property when I'm gone. That's all a trust is, a written agreement addressing those three things. Every trust has to have four parts, okay? Every trust needs to have, the first line here is the grantor. That is the creator of the trust, the one granting it. Every trust has to have a trustee. That's the manager of the trust. Every trust also has to have a beneficiary. Who benefits from the trust? You can have a couple different types of beneficiaries, depending on the type of trust. You can have a principal beneficiary, meaning who's entitled to what's inside the trust. You can have an income beneficiary, meaning who's entitled to any income generated within the trust. And ultimately, the fourth requirement for trust is the trust has to own something, whether it's a house or an investment account. If it's not being funded on day one, you'll always see on the last page of the trust what we call the Schedule A. You've got $10, right? So that's the symbolic funding of the trust so that it can be created. A trust is a separate entity. You can think of it as a corporation if you'd like. It has its own independent status, okay? And then depending on the type of trust, it accomplishes different goals. There are two types of trusts, revocable trust and an irrevocable trust. And these trusts work very well with Medicaid. The revocable trusts will help, as I'll talk about, do certain things. The irrevocable trusts, as I've already shared, are going to be that asset protection trust so that Medicaid can't go after it, okay? So again, two types of trusts. There are primarily two reasons why people do trusts. First and foremost, avoid probate. Secondly, asset protection, okay? So which does which? Unfortunately, there's been times where we've sat with clients or children of clients, and they're like, oh, no, we're good. We have a trust. Okay, Joseph, can I see the trust? We'll look at the trust, and it's not irrevocable. Or it says it's irrevocable, but the attorney drafting it didn't really know what he was doing or used a bad form from some other attorney that shouldn't have been doing it. And it says irrevocable, but it has the wrong language inside. It has the terms of a revocable trust built into an irrevocable trust, which means it's not a protection trust at all. Okay, so getting it done right the first time is always a prudent way to go. So back to the chart here. We have revocable trusts and irrevocable trusts done for two different purposes, avoiding probate and asset protection. A revocable trust serves one significant purpose, and that is to avoid probate. Do not just gloss that over. That is a plan in and of itself. Avoiding probate is significant in this day and age. Again, other webinars on our website and YouTube page talking about that. the time savings, the financial savings, the privacy that is saved by avoiding probate, 100% valid planning tool. A lot of families implement those. Now, in relation to Medicaid, a revocable trust can be helpful in that it avoids what's called estate recovery. Okay, remember I said that before as one of the concerns and consequences. So revocable trust can play a hand in it. Not always needed in a Medicaid application for a Medicaid application client, but the family can use them. Okay. Now, does an irrevocable trust avoid probate? Yes, it does. Every type of trust, as long as it's drafted properly and the asset is owned by it, will avoid probate. Okay. Now, asset protection. The irrevocable trust is built for asset protection. Again, the caveat, as long as it's got the right language in it. I can't tell you how many times we've sat down with families thinking they're good with an irrevocable trust, and it has the wrong darn provisions in there. All right. So you want it done you want it done it right the first time. If you're thinking you're going to need care, or if you didn't have a good gut feeling about the attorney that did it, we'll take a look at it for you. Okay, make sure it has the right language. Now, the reason I'm doing this slide is to share with you that the revocable trust does not do anything about asset protection. Okay, the revocable trust, because it is a transparent entity that the grantor retains all control and all access to, there therefore is no asset protection whatsoever. Okay, so in our trusts and Medicaid program here, the primary trust we're talking about is the irrevocable asset protection trust. That's what should be done as a part of your elder care protection plan once you hit 65 years of age. Okay. Now, why? Tell me about this irrevocable trust. So let me do that. Give me 1 second. An irrevocable asset protection trust. And oh, by the way, when I first started, I told you I'm using Google right now. I'm not digging it too much because it just shows some slides, it shows everything, and some slides it goes one by one with the animations. So ideally, not all these points would be up on the screen right now, so I could show you one by one. And you're not overwhelmed by looking at all those, but bear with me. I'll try to get it fixed for next time. The top line, I'm going to talk about that first. An irrevocable asset protection trust. Again, you want to get it started. And the reason you want to get it started and funded is so you can start that Medicaid look-back period. All right. Even though the look-back period for home care does not yet exist, it will. And when it does, they will look back because you'll be applying for your Medicaid services after. All right. So start the look-back period. Now, the Asset Protection Trust has one main significant rule. And that rule is the next line here. It says no to the principal. Whatever is inside this, the irrevocable trust, whether it's a house or a $200,000 investment account, that is called the principal. And in an irrevocable trust, that principal can never be gifted back or distributed back out to the grantor parents. That's how we get the asset protection. All right. We have to do it that way. Think about it. If mom and dad set up an irrevocable trust and put 200 grand in there, but they have the ability to pull it out, or you as the trustee have the ability to give it back to them, that gives, like I said earlier, control, and it gives access. And if the parents, the grantors, have control and access, then so does Medicaid. Okay, so we have to deal with this rule. We have to have it in the irrevocable trust in order for it to be an asset protection trust. Now, 2 points. Whenever we have to include that in our trusts, not everything ever goes into an irrevocable trust. Okay, if you recall earlier, I said Medicaid allows you to keep that 16.8 plus your retirement accounts. Okay, so retirement accounts never go into a trust like this. In addition, depending on how close we are to the need for Medicaid, you leave money outside of the trust. You don't put your checking account in there. Your income doesn't go in there. If you've got 50 grand to your name in a house, the house goes in the trust, the 50 grand stays out. All right. So that you have spending money. So you have some security. Don't ever forget the attorney, we are representing the parent here, the one setting this up. This isn't about helping the kids get a bigger inheritance. They will if everything is done right, but that's not what this is about. We want mom and dad, we want the client to have enough security and comfort knowing that they have access to money, that they don't have to go to a trustee or a child to get money out. All right. So again, not everything goes into the trust. Second point, we always build in a back door. Okay. So there will always be a back door in an irrevocable trust like this that says money can come out, but it just has to go from the trustee to a child. Okay. So there's always a back door. We just kind of have to go around the trust to get there. All right. Next point. If there is cash in the trust or investments in the trust, or if there's a rental property in the trust, there will be income. And that net income has to get paid somewhere. It can go to the grantor creators, the parents. It could stay in the trust, or it can be distributed to the children. There's choices. If the trust is done right, it'll say that mom and dad have the right to live in that house for the rest of their life. They can't be kicked out. They can't be made to pay rent. They have the right to live there. All right. Again, security and comfort. Real estate taxes remain the same because of that right to live there. So you're not going to lose your exemptions. All right. That's valuable, especially on Long Island. You have the ability to sell. You've got the ability to buy, all within the trust. All right. As long as it's done correctly, no new 5 years, no new look back period at all. Control. Even though it's an irrevocable asset protection trust, again, you're keeping control because you've got the right to live there. You can sell, you can buy, you can keep the income if you want. You can also, down by the trustee line here, is you can, if you have a trustee that you love working with, your child, your daughter, but then all of a sudden things are turning sour, unfortunately, you can always fire the trustee. So there's a level of control here that's very beneficial and comforting in that you're not stuck with the trustee you chose if, God forbid, there's a falling out. Same thing with beneficiaries. So even though it's an irrevocable trust, you can change the beneficiaries, okay? We build in what's called a trust protector, which is somebody outside the family that can even amend the trust later on, all right, important. Other taxes, I mentioned real estate taxes, but income taxes and capital gains taxes all remain the same, okay? So if you're looking at paying income, if there's $300,000, it's making interest and dividends, the parents are paying the taxes on that, all right? Capital gains, if you sell your house, you're keeping that exemption. All good and important stuff. And the last point on this page, even though it's an irrevocable trust, if need be, we can always revoke it, all right? So we can literally have our cake and eat it too, all right? There's no reason a family, especially owning a home on Long Island over 65 years of age, does not have a trust like this in place, okay? Next, when should I start my asset protection? When should I start my Medicaid process? The elder care protection plan or the life care plan? You know the answer. It's now, all right? Based on the timeframes that we have and based on the favorable laws that we have, based on the reality that time keeps ticking away and we want to get the clock started, the sooner you do the asset protection, the better, okay? The sooner you start the Medicaid process. If mom and dad need care now, get it going. There's no reason not to, all right? The sooner you get it started, you apply before the law changes or before they postpone it again, but then the sooner you can get help in the house, okay? That's what this is about. Now, as I shared before, legal, financial, and care. Everything we do here at Tully Law Group is to make sure we're going to protect as much of the assets as possible, get Medicaid to pay the bills, and help your loved one get the best care possible, okay? A traditional elder law firm, and I have a lot of colleagues and friends that run those traditional elder law firms, they operate this way. They'll do the legal and the financial. That's what they do. They're lawyers, they're paralegals, right? They'll do the wills, they'll do the trusts, they'll do the Medicaid work, and the care, that's off to the side. You can hire your own care manager, you can cobble it together yourself, you can keep trying to advocate on your own, even though you've never done it before. That's the current elder law state right now. Where we're different, and we have colleagues throughout the country that practice this way as well, it is what's called life care planning. We're all one team. We're all here under one roof, working toward the same goals of protect the assets, get Medicaid to pay, and get the best care possible. All right. Again, attorneys, paralegals, and elder care coordinators all supporting the family through this entire process, whether it's putting the trusts together or applying for Medicaid because it's time to do that. All right. The two of them work together and we can help. We can put that plan together, put the protection together. I want to thank you for joining me today. It's been, I know I kind of rushed. It's been one of our longer programs I like them to be about 35, 40 minutes, but we've gone over a little bit. If you have questions, all right, feel free to call the office. Call and talk to Angela. Call and talk to Lorraine, 631-424-2800, 424-2800. You can email me directly, Brian, Brian, at TullyElderLaw.com, TULLY, elderlaw.com. Yes, Facebook and Instagram, of course. Let me see what questions we've got, folks. First question, does the stepped up basis still apply to assets contributed to the irrevocable trust? Thank you, Ian. Good question. And the answer is yes. Again, website and YouTube, we have webinars talking specifically about the trust, and I get into a little bit more there. But the answer is yes. The irrevocable asset protection trust, or what they call a Medicaid trust, is ultimately a grantor trust, which means that it has certain powers and certain privileges built into it. And two places the capital gains come into play is if you sell, you keep your $250,000 capital gains tax exemption on your primary residence. And children or beneficiaries will inherit with a step up when you ultimately pass away and they inherit. All right, thank you. Next question. My spouse is 15 years younger than me. Can he or she be the trustee of my trust? I'll answer that first. If we're talking about an irrevocable asset protection trust, the answer is no. In the world of Medicaid, spouses, a married couple, are treated as one unit. Okay, so we have ways to shelter and move assets between the two, but if one spouse is a trustee for the other spouse, it doesn't work. Okay, it's always safer to have a child or friend or other sibling, for example, as a trustee. Okay, the next point you had, what happens to the assets of the trust after I pass away? Well, Sandy, it kind of acts like a will. Obviously, there's no probate. I shouldn't say obviously, but there's no probate. The trust will have provisions and distribution language that says this trust remains for the balance of my life. I get the income. I can't get the principal, like I said earlier. I can change my trustees. I can sell my property. And then when I pass, the assets go to child ABC or nephew 1, 2, 3. All right, you build that in there and it gets to them without probate. We could also build subtrusts in there if they're too young or if, God forbid, they have disabilities. Does the elder care protection plan include a trust? That's Sandy's last point, and the answer is yes. The irrevocable trust is the cornerstone of that elder care protection plan. Next question. If you have a revocable trust from another state and have moved to New York, what should we do now? Good question, Joseph. I quite honestly get that in the reverse a lot. Where we have clients here in New York heading out, right? Those are the headlines these days. But the reality is you should sit with a New York-based attorney, and we'd be happy to do that, just to make sure you've got all the right language built in there, okay? The trust should be fine. You shouldn't have to amend it in any way, but it's good to get it looked at. I'd be more concerned about the power of attorney and the healthcare proxy, okay? And if you're over 65, then you want to start the asset protection with the irrevocable trust, all right? Thank you for the question, Joseph. Do we set up Medicaid pooled income trusts? Hi, Karen. Yes, of course. That is done together with our community-based Medicaid work, which is a part of our life care planning service. But yes, we do the pooled income trusts. If you need to know more about it, I'd be happy to answer. But we do, again, more Medicaid information on other webinars that are out there. Can a Medicaid recipient establish a trust to protect assets and Medicaid eligibility if they win a settlement in a lawsuit? Yes, they can. Just had a long phone call with a potential client on that this morning. So depending on which Medicaid program they have, community-based Medicaid or chronic care nursing home Medicaid, there's different options. assuming it's nursing home, you're going to be looking at what's called a first party supplemental needs trust. Um, Keeps the Medicaid benefits in place. You can shelter the asset, use the asset, but the first party, unfortunately, has something called a payback provision. Not the best outcome. The best outcome is for the parent to set up a trust before it even hits that Medicaid recipient beneficiary. If it's community Medicaid, we have different options as far as outright gifts to a loved one or a supplemental needs trust. The concern, though, is moving forward if that community Medicaid beneficiary needs a nursing home within the next 5 years. We have to look out for that. Thank you for the question, Andrea. Can you swap out assets in the irrevocable asset protection trust? Good question, Patrick. Yes, the power of substitution can be built in. It's not always in there. Depends on the family, depends on the circumstances, but that is one of the grantor provisions as far as substitution. Stacy, if have irrevocable trust but didn't change or file the deed into the trustee's name, is the trust not valid yet? It depends, Stacy, on what, whether that Schedule A has that symbolic $10. Have I ever seen a real complaint that the deed wasn't funded in yet, just to as far as the validity of the trust? No, I haven't. What I'm more concerned about is the trust being set up is one date, but then the deed being transferred or funded into the trust, that's the other date. That's the start of the look back period. Okay. So if you haven't put the house into the trust yet, you need to get that done as soon as possible to start the 5 years. Okay. We've got lots of questions today. Mary, if the asset in an irrevocable trust generates income, does this income affect Medicaid eligibility? It depends where the income's going, Mary. So if the income is payable to the grantor creator, who's also the Medicaid recipient, then yes. If they're in a nursing home, then the nursing home Medicaid allowance for income is $50. Everything over that just gets paid to the facility. So it's not going to jeopardize their Medicaid eligibility. If it's community-based Medicaid, then the excess income from the trust can be deposited into the pooled supplemental needs trust that Karen asked about earlier. The reality there, though, is you want to spend that every month. And if it's just excess income that doesn't get spent, then there's a risk of losing that down the road. Again, doesn't jeopardize Medicaid eligibility, but you might lose the income down the road. Can you prepare and file a deed for the client for a trust that's already created? Stacy, you can, but you want to be careful, right? You got to look at the whole picture. And if there's already assets in the trust, and if the trust is already a couple years old, then you probably want to start from scratch. Because if you put the house into the trust now, that's a whole new 5-year window. And if you already have assets in the trust, then those are going to be jeopardized if a nursing home is needed within that new 5-year window. So we got to look at the whole scenario. All right. Hopefully that helps. Thank you very much, Amy. I appreciate you being on the webinar. All right. Let me see. We do have a couple more questions, folks. Hybrid, Marjorie's asking a long-term care insurance. I think a hybrid long-term care and life insurance policy is a great idea, as long as it has sufficient, robust benefits. I would say $300 a day home care, $400 to $500 a day for nursing home care with an inflation rider would certainly cover what's out there. But yes, the hybrid is a good way to go. What else do we got here? Once you open a revocable trust, do you still have a look back period for community Medicaid or Medicaid? So the look back period, Mr. Anonymous, the look back period exists no matter what for a Medicaid applicant. You file for Medicaid, there's a look back period. 5 years is the only look back period right now for nursing homes. When the home care one comes out, yes, that the look back will exist. The question is whether they're going to find any transfers that can be penalized. Right, that's the concern. So if it was a transfer to a spouse, those are never penalized. If it was a transfer to a child or to an irrevocable trust, then yes, you can have your penalties in those scenarios. A transfer to a revocable trust, though, is not a gift, because as long as it's your revocable trust, it's a transparent entity. So no penalties with the revocable trust, which is good, but the bad side is it's still your asset, okay? And Medicaid can look at it. Okay, if an irrevocable trust is already in place, but it's not 5 years yet, can the trust decant to a new trust without restarting the look back period? Great question, Jean Marie. I would say yes, because to me that would, as long as the statutes followed, and you know what I mean by that, as long as the statutes followed, I would liken it to a distribution from the trust. Okay, so mom can put 500 grand in a trust today, an irrevocable Medicaid trust, and then next month the trustee can make a distribution to a child. That is not a new gift from the parent; it's just a distribution from the trust. The penalizable gift was the initial 500 grand going into the trust. Okay. So I think you'd be okay with that. If you want to talk about it, you can give me a call. Again, thank you. We're done with our questions. A real great time today. Please keep an eye out for our webinar come March. I have a feeling it'll have something to do with St. Patrick's, like we've done in the past. But again, thank you. Be well. If we can help, please reach out and get your stuff done. Thank you.